next slide, please, Jen. I can probably skip. Yeah, so today, lovely, and keep going, that's fine. So today we're looking at avoiding disputes, and if they can't be resolved, and fair to say that in some instances, even on the best projects, they can't be resolved in dealing with them. So it's basically split into three today. So the first bit is sort of common causes of dispute, which is a slide you can see. Then I'm going to have a look at avoiding disputes, which is really about documents, getting your documents in order, document control, etc. So, not the most exciting subject, but really, really important. Can't stress it enough. And then finally, if you are in a dispute position, I'm going to sort of look a little bit at strategy tactics and what you might want to do in terms of preparing, setting out your claim, etc. Not going to look at adjudication or court proceedings because I'm guessing that by that point you'd probably have your lawyers on board. So in terms of common causes of dispute, and I think it's always helpful to look at why we have disputes, and what commonly is what commonly comes up. Sorry, I can see two of me, but one of me is bad enough. Okay, so common causes of dispute. There's two slides on this. So the first one is start on site too early. So in my experience, this is often a cause of dispute, generally because the parties, particularly the contractors, subcontractors, etc., haven't properly prepared. And of course, if the start on site is too early, as we know, being on site is quite expensive, which, of course, as soon as parties are incurring costs, there's the likelihood of a claim. So that kind of goes hand in hand often with letters of intent, because often that is done in a bid to get work started when things haven't been properly prepared. So often a letter of intent is done for design to get going, sometimes site investigation, sometimes wider works. Letters of intent are risky in themselves, and there's case law where the judges say you should never sign up to a letter of intent. But of course, this is the real world. But letters of intent are risky in that they need to specify exactly what work is to be carried out, at what price and what timescales. And if it doesn't, that can cause problems between the parties. But also if it does, and particularly the party carrying out the work doesn't get the letter of intent extended once it's reached one of those parameters, that can cause problems. The third bullet point, buying work or buying experience, it's amazing how often that happens. And the typical scenario is, well, it's a double problem, because quite often the work is bought at a lower price than would ordinarily be tendered to get that experience. And the second element, the second potential problem is that if you're not experienced in that type of work, the chances are you may have underpriced it in any event. Also, that can cause a problem in circumstances where, for example, a business needs the work because it's short of work, and then by the time it's completing the work, an hour, a year, or possibly 2 years later, people may have moved on, they may have forgotten why they tendered such a low price, and may think, oh well, they need to make up the losses or the balance of the money spent through claims which possibly aren't legitimate. Another problem is opting for the lowest price. So even for the paying party, that's not always a good idea. The price needs to be examined because, you know, worst case scenario is the lowest price potentially could result in insolvencies, and then the paying party has to engage a new contractor to carry out the work. Also things like misunderstanding or an unclear scope of work. The scope of work is really, really important. It's probably the ground for most changes, particularly in an NEC form of contract. And, you know, sometimes the scope of work is so voluminous that the parties doing the work don't have chance to review it properly, and or, you know, the scope again could be voluminous and or have discrepancies in it. So, you know, it might say on one page the work has to be done in one way, and on another page it needs to be done in another way, which then creates disputes. The other one is what I've called surprises. So not being clear on some of those sort of neutral risks. So not things where one party or the other has done something wrong, but things like ground conditions, third parties, so statutory undertakers. I put weather in there as well, you know, where the contract has either been changed or is unclear as to who bears those risks, or the party carrying out the work, the contractor or subcontractor, being optimistic and assuming that they're not responsible for it, but actually finding later on when the risks happen that the contract says they are responsible. So next slide, please, Jen. So a few more causes of dispute. So late notification of claims and cash flow problems. So the notification point, particularly relevant to NEC. So for example, having to notify a compensation event in the main contract 8 weeks. If that's not complied with, the contract says that the claiming party is not entitled to any time on money. So where I'm talking about notification, I'm talking about those killer notification clauses where if you don't comply, you lose an entitlement. Also, cash flow problems can sometimes mean that particularly a party doing the work, is sometimes looking for claims to try and mitigate their cash flow problems. Next one is generally a bad bargain or the late appreciation of reality. So high liquidated damages is a good example of that, where possibly a contractor signs up to them, possibly thinking they're high, but, you know, hoping, fingers crossed, it won't become relevant. And then when it does, the fact that they are so high causes a problem. And now, I mean, a few years ago, the position used to be that the paying party could challenge liquidated damages if there weren't a genuine pre-estimate of loss. Case law's changed that now, so it's really difficult to avoid high liquidated damages. The court now very much takes the view, as will adjudicators, that if you've signed a contract, then you've read it, you've understood it, you've accepted all of it. So, you know, just be warned about that. And also, you know, the point that I've already made about ground conditions, misunderstanding the scope, and also critically, and I've come across this so often, particularly for subcontractors, but also contractors, where their caveats and exclusions are not included in the contract, even though they have been the subject of the tender and their pricing. But most contracts will say that what is in the contract is binding between the parties, and elements that have been negotiated and discussed pre-contract but haven't been included in the contract, they're basically of no value. They are irrelevant. What is in the contract is important. So if you tender, if you price on the basis of caveats and inclusions, you must make sure that those caveats and inclusions are included, are sewn into the contract in some way. And added to that, you also need to make sure that those caveats and exclusions, come above any other clauses so that you don't find that you end up with a discrepancy within the contract where, I don't know, a contractor's caveat might say, there's no allowance for ground conditions. So any ground conditions are an extra in terms of money and time. But there may be another clause in the contract that says contractors wholly responsible for ground conditions. So you just need to make sure not only are the caveats and exclusions included in the contract, but that it expressly takes priority over every other clause in the contract. And then finally, lack of collaboration. This particularly relates to defects. So typically defects after completion and, defects after the defects period, albeit that it can be at any stage. So this is particularly as between contractor, the design team and the design subcontractors, where, all sorts of generally human errors occur. So, I've seen things like the architect's design being emailed to cladding and roofing subcontractor, but unfortunately it wasn't the up-to-date design that was issued. That problem, in amongst several others, ended up with a leaking roof post-completion, post-defects period, and extensive repairs being required. And so, just be careful, I suppose, particularly for main contractors, that you liaise and you ensure that, all of your team liaise properly. So next slide, please. So we're going to look at how disputes generally are dealt with. And you might think, I've already said we're not going to look at this in detail, which is absolutely true. The reason that we're looking at this is so that you can plan your strategy as you see a dispute arising. I'm not talking about, right, we're going to start an adjudication. This is about planning. So we were talking earlier about defects, and the second bullet point actually states here that generally defects claims will be dealt with in court proceedings or arbitration if that's picked as an alternative to court. So you're sort of looking at a 12-month period to get to trial in court proceedings. So if you're talking about court proceedings, there's a precursor to that, which is the fourth bullet point down, the pre-action protocol. So it says there it's typically dealt with for defects claims, but my view is it can be used for all sorts of claims. And you might want to follow it without actually calling it a pre-action protocol process. So fundamentally what it is the claiming party will send a letter of claim, and we're going to look at a letter of claim later on. They'll send a letter of claim to the other party. The other party then responds, and then the idea is that somehow the parties then meet to try and either resolve the dispute or reach agreement on the areas that they can agree before going to court. It's helpful in terms of strategy because, as we'll see when we look at the letter and the components of it, it gets both parties to consider each other's case, hopefully realistically. And in that context, the third bullet point is relevant because one way of that process of getting together to try and resolve the claim or, agree the issues that you can agree on, even if you can't resolve the whole thing, is mediation. It doesn't have to be mediation. It can just be a parties meeting. Mediation is different because you have an independent mediator who attends. The parties usually have different rooms, and the mediator shuttles between the two parties to try to broker a deal. And you might think, oh, well, that just sounds really unlikely in terms of achieving a deal. But actually, it's surprising how successful it is, possibly because the parties usually will have to commit to a day. Sometimes for bigger disputes, 2 days. And I think psychologically, they arrive on the day and they're wanting to resolve it. They're wanting to kind of get this matter off their desks, finished with, so that it can move on to something else. And I think also because having that third party there makes each party, or all parties, if because sometimes, particularly with defects, there might be numerous parties, gets the parties to be a bit more realistic about the merits of their own claim and the merits of the other party's claims. So the top bullet point talks about adjudication. So that's usually what we use if there's an account claim. So that would be the party carrying out the work, claiming time and or money. So it would be dealt with as a merits claim. So whilst adjudication's a quick process, so 28 days or so, usually it's a bit more than that. And that's on the merits. The idea was that adjudication would be a rough and ready way of resolving a dispute. It's not quite as rough and ready as we'd anticipated. So most parties have representation, so usually their lawyers on board. It goes into a lot more detail, a lot more legal argument than I think we'd thought initially, but I think because of that, at the end of it, whilst it's not binding, the parties can still go on to court. Generally, the parties will accept the decision as binding because they feel they've had a third party determine it. Smash and grab's slightly different. If you didn't attend last month, smash and grab is about obtaining money, usually for the contractor in a contract, subcontractor in a subcontract, where the proper payment notices haven't been served by the paying party. So again, that's usually on a very temporary basis. But of course, it gives real leverage to the party if they succeed in a smash and grab, because they get the advantage of the cash flow. And it also means that the other party then has to start a merits adjudication after they've paid to claw back any money that they're entitled to, which is always going to be a challenge for a party who's not a construction party. So a developer, so typically developer pursuing a contractor is always going to be a challenge for the developer. But generally, the party who succeeds in a smash and grab has that leverage of being able to go into negotiations, having quite often been paid sometimes more than they think they're entitled to. So, it's far easier to negotiate when your leverage is that you are going to pay some money back than the other way round. So generally for contractors, subcontractors claims, we're looking at adjudication, but in terms of before starting an adjudication, because of course adjudication, it is a commitment in terms of time and fees. And also it is a risk in that once it is started, it's just down to the determination of the third party adjudicator. And there are always risks in that instance, as there are with court proceedings. So in advance of an adjudication, there are things that each party might want to do, particularly the claiming party, and that might involve pre-action protocol or similar process. It might also involve, so the penultimate bullet point, assessing the type of claim that you have so that you can decide on your strategy. Always really important to have a strategy because it shows that you're thinking, longer term with regard to the dispute. So, assessing the claim might be, well, it's going to be an adjudication, but is there any smash and grab opportunity, or is it going to, of necessity, have to be a merits adjudication in advance? You know, do we comply with the protocol or something similar to the protocol? And then finally on this slide, when we're thinking of strategy, always remember that an admission or a part admission or also an agreement could be valid. Don't forget about it, particularly if you're the claiming party. So an admission that, you know, yes, this is a compensation event, but we don't agree the quantum, you know, don't forget about that concession. An agreement as to, you know, the value of a particular compensation event, don't forget about that, you know, because they are, you know, strong points to make in circumstances where the other party's trying to row back on agreements and admissions. Next slide, please, Jen. Okay, so this is the sort of middle section for today, which is about the documentation and protecting yourself. So this is pre-contract, contract negotiations, and I think it's always good to have a pro forma or some document that the parties negotiating the contract can complete, just to as a sort of sense check that all the key points in the contract have been covered before signing, but also, and I'll talk about this later, to use later on in the project. So the aim here is to kind of cover off all the key points that you would want in a, you know, 1-page, 2-page document. And I wouldn't envisage that, you know, it's formatted as a sort of legal document with lots of words. I would envisage it, you know, being lots of boxes, you know, possibly some of the boxes linked, so that the information can be inputted as the negotiations go on. So this is sort of my list of things that you would want to have in from a contractor or subcontractor perspective, where you're the party carrying out the work and wanting to be paid for it. Some of them, I mean, hopefully they're all self-explanatory. Some of them, things like the payment dates halfway down the left-hand side, you know, you might want to have those included. I think that's a good discipline, because so often I've had clients approach me wanting to proceed on a smash and grab because the other party hasn't submitted a payment notice or a pay less notice. And when you look at the dates for the notices for payments, it's such a muddle that it's really difficult to work it out. And you need to work it out before you can run your case to adjudication. So I think doing it in the pro forma is a sort of good discipline to get into, because it forces you to check that the dates are clear. Excuse me. The penultimate one on the left-hand side, conditions precedent. These are what I call killer deadlines, where they require you to serve a notice to the other party. But if you don't serve a notice, the penalty is that you don't get any award of time on money. So, you know, if they're going to apply, you know, to me, they need to be stated in here, and the time limits. The other one is on the right-hand side, halfway down, blockers for payment. So again, similar provisions. So for example, a common one is if collateral warranties haven't been provided, then 10% of the interim payment will be deducted. Sometimes no interim payments will become due. So, you know, useful to know that, because, you know, that's not going to be great for cash flow. The bottom one, the specification, would be something around, I mean, this isn't a legal point, it's more a technical point around, you know, the requirements in the specification for the party doing the work to comply with. Next slide, please. excuse me. So we've now got to contract execution stage. So hopefully, if you're starting work, we know that the contract is agreed and executed. If not, you might be working on a letter of intent, so make sure those key points are kept up to date. So the scope of work that you're going to be carrying out, the timescale, the amount of payment, but also remember to keep an eye on this letter of intent. What you don't want is for it to be extended and extended all the way through the project, and the contract itself is never entered into. The other thing is this final bullet point: ensure the relevant people are familiar with the relevant provisions. So to me, this is making use of that pro forma that we've just been talking about. So tailoring it so that it's useful for the people on site, so that when, as typically happens, I think, projects being tendered for and priced and the contract agreed by one team, it's then transferred to the team on site who'll be carrying out the work, so that it ensures that they're familiar with the relevant provisions, and they know clearly how to operate the contract. Now, I'm not saying that the pro forma should be used in lieu of a proper handover meeting. I just think the pro forma is helpful in advance of that meeting, because it's really helpful to kind of for the new people to familiarise themselves with the key provisions, but also for them to take it away and use it through the project. And also, projects can go on for a while. People, leave the organisation, move on to different projects, new people come in. So, my view is that pro forma will be helpful throughout the project to keep new people up to date. And, obviously, it can be updated as matters go on. Next slide, please. So to protect yourselves, diarise key dates. Much of this we've covered. Conditions precedent, those are those killer deadlines, diarise them. Be aware of procedures to be followed. So obviously we know that NEC is very procedure heavy, less so for JCT, but compensation events, programming, etc. for NEC. For JCT, variations, extensions of time loss and expense, etc. Also, noting the technical risks, and as I said there, possibly use that contract pro forma. Next slide, please. So, still within this middle section, so the documentation. So this is about the documentation that is supplied and provided throughout the build, so through the project. So it's quite a dull topic, I think, but really, really important. So in terms of priority, your contract is generally the key document, but there then follows on a lot of communication about how the work is going to be carried out, etc. As well as the contract, don't forget about other agreements. So there may be all manner of agreements made and reached through the works. Yes, we agree this is a variation. Yes, we agree these costs. So, what you sometimes find is agreements are reached throughout, and then one of the parties might try and sort of row back and avoid some of those agreements at the end of the project. Keep an eye on those agreements. Try, don't let the other party renege on them. And part of the way of doing that is just continually reminding that party that agreement has been reached. And once you have an agreement, you can't row back on it. But also critically not forgetting about it yourself if it's the other party, trying to renege on it. The key documents in kind of high level are project documents, I mean here, are the documents that have been communicated between the parties. So the second sub-bullet point, the correspondence, letters, emails, texts, pro formas. It's key because as opposed to documents that have just remained internal, because with correspondence, the other party has had the opportunity to dispute what has been said. So particularly if they don't challenge it, if they don't dispute it, I mean, even better if they agree it, but if they don't respond, there's an argument that they have deemed to have accepted it, whereas documents that aren't communicated to the other party, there's no opportunity of making that argument. So the same applies to programmes. The third sub-bullet point, programmes, drawings and plans. If they've not been communicated at the time, they do have some evidential value in a dispute, but less than the documents that have been communicated at the time. So particularly if there's a discrepancy, one document that hasn't been communicated says one thing, but a document that has been communicated says another, then generally the one that's been communicated will take priority. So that's why this is important. Photographs are really, really helpful, particularly because, of course, now we tend to have iPhones are similar, so it's all dated and timed, which is really helpful. Minutes of meetings similarly. Internal notes less useful, but they are still useful. But of course, they generally aren't communicated to the other party at the time, and therefore not quite as useful. With minutes of meeting, if you're the party who prepares them, make sure you do prepare them. Personally, I think there's little point in having a meeting unless minutes are provided, because so often everybody's agreeing actions, and then sometimes they rarely get completed. So for me, the whole purpose of having a meeting is the minutes that emanate from it. If you are the party who is sent minutes, please check them and please respond to the party who's prepared them if you do not agree them. I had a whole adjudication where it was based on minutes of meeting, where it was claimed that my client had agreed something through minutes of meeting that they hadn't checked. Now, fortunately, we managed to find in the adjudication timescales several pieces of subsequent correspondence which showed they hadn't agreed it. But of course, a far easier solution would have been them to have checked the minutes and responded and said, we don't agree, that wasn't what was agreed at the meeting. So please, I think that's one of the most tedious tasks ever, checking minutes of meeting, but please make sure somebody does it. Next slide, please. So yeah, I mean, this is just about if you get into a claim, your records are critical to support the claim. So critical in terms of entitlement, so a request for work to be done, or for example, if extra work is requested, contract administrator may say, can you do this extra work? I'll put it in an instruction. It's always a good discipline, I think, for the other party, the party doing the work, to just confirm the discussion in writing, just to confirm our discussion. You instructed us to proceed with this work. You agreed it was a variation. You said you were going to issue an instruction. Please let us know if we shouldn't proceed. Just in case that instruction doesn't come through, or just in case there's a later on when the work's being carried out, the contract administrator says, well, no, I didn't agree it, or I didn't agree it was an extra, a variation, a compensation event. So, really good as much as you can to record things in writing. It's relatively easy now in email. Try to avoid text, but they're still, you can still use texts, assuming they haven't been deleted. Obviously, reporting obligations are useful. So, weekly, monthly reports of progress, etc. Again, make sure they're accurate, because once they're submitted and agreed between the parties, it's then really difficult in a dispute to try and row back and say, oh, well, we said that bit of work had been completed, but in reality it hadn't. And also, quantifying the claim, documents to prove what materials cost, timesheets showing which personnel were working on a specific piece of work and for how long, all support the quantum of the claim. Final bullet point is, be consistent. And I think probably most of you will do this, but have pro formas for all the types of claims and notifications that need submitting under the contract. It just makes it so much easier for the site personnel to complete them. It avoids them missing some information. And it avoids people spending time basically reinventing the wheel by trying to, each time think, right, I'm serving an early warning notice here. What do I need to say? What clause is it, etc. So next slide, please. Yeah, so just a quick note here. The first bullet point, be objective and professional in all your documentation preparation, even the internal. Don't lose your cool. I don't mind a bit of emotion, a little bit of frustration. Isn't can sometimes be helpful. But what I would do is always assume that a third party is reading the documentation. And I think that's a good discipline to get into, because it will ensure that it's polite and professional, etc. But also, I think it helps to avoid the sort of one-line email where you are talking to your opposite number and you know that they understand everything, so they will understand your email. And sometimes that can lead to ambiguities and lack of clarity. But also it means that if you are in a dispute, it makes it difficult to, it often means that there has to be an explanation as to what that one-line email meant. So quite often thinking about, this is going to be read by a third party will help people to think, right, I need to put a bit of background here. I need to explain, what is essentially going to be, a one-line email. So the background goes in and it just gives the whole thing more impact. Now, you might be thinking, well, we would never go to court over a dispute. If we had a dispute, we would never go to adjudication. But hopefully you'll see when we look at a letter of a claim where that might be useful in a more practical context. And yeah, site diaries, obviously keep them consistent, try and keep them impartial. Next slide, please. Yeah, so that's just minutes of meeting. I've covered that. Okay, so this is moving on to the final sort of section for today, which is about strategy stroke content of a letter of claim. So we've already looked earlier at, thinking about, a claim is coming up, you're not ready to refer it to adjudication or to court. What you would ideally want, and I think this applies in, it must be 99.5% of cases, the ideal solution is to get it resolved before adjudication or court. So, this is about trying to have a strategy which leads to an effective way of convincing the other party that they should settle this dispute. And at that point, then you're just talking about the numbers. And if you can't reach an agreement on the numbers, then everybody's got the opportunity to go to adjudication or court. But you need to get yourselves into the best position possible to get some negotiations to try to avoid that. So as we looked at initially, first of all, you need to think wide. So and high level. What is your strategy going to be? Because if you're thinking of smash and grab, you might want to be getting some legal advice pretty early on, just as to whether smash and grab might be successful. And if that's the case, you're possibly just going to, leave all of this where it is and start the smash and grab. But at that point, you'll have your solicitors on board. But this, and I mean, typically what you would do would be to start the smash and grab and hope that that might force some very quick negotiations before the parties get too far into the smash and grab. But assuming that's not the case, the chances are you are going to be on an account claim heading towards adjudication. Before you do that, what you might want to do is what I would call, it might be a pre-action protocol letter, it might just be a letter of claim. And the purpose of this slide is to sort of set out what the letter of claim might include. And the idea is to get this letter in front of someone high level within the other organisation, to get that person questioning the people within the organisation who've been involved in it, and to give that person almost the answers to the questions that they will be asking. So the kind of aim is to get that high level person thinking, we need to deal with this, we need to get it resolved, we can't let this go to dispute. So how are we going to do it? Well, this is sort of a sort of template headings for a letter. It's not perfect. It depends on each individual dispute, but this is sort of a rough template that could be used. So I think you would start off with the purpose of the letter, be bold, be clear, and be confident. The purpose of this letter is that, we've submitted interim applications, the sum of whatever, remains unpaid, our extension of time, hasn't been granted in full. We consider we're entitled to both. So, you're setting out, what your high level view of the position is. So the next one, the nature of the claim. So this is a little bit more detail. What's the claim about? We've got 27 variations, compensation events. We're entitled to, additional time of, 20 extra days, etc., etc. Next, the history of the claim. So this in particular could be quite useful in setting out, as it says here, who did what, who said what, and use your documents. So particularly those project documents to show who did what, said what, agreed to do what, etc. So this in particular is the point at which you hope the other side's director, high level person, is going to be looking at this and thinking, oh, right, so our people said this, they did that. All right, I need to question them about that. If you also include the documents or quote them, I like to quote documents, it's also giving them the next question to ask their people. So, the first question to ask them is, this letter says you did X or you said Y or, you agreed P, etc. And if they say, oh, no, that's not right, let me explain. The director has then got the answer from you already, well, that's interesting, but this document, records that, in the minutes of, particular meeting that you agreed all of this. So, as I say, you're sort of giving that director level person the ability to look critically at the claim and see the good points in your claim. So the next point is, quote the relevant contract provisions. 2 reasons. First of all, it avoids the person who's been questioned by the director about this from saying, oh no, that's not a claim under this contract. Oh, well, that's interesting, because in this letter the contract clause is quoted and it seems that it is a claim. It also, the second reason I would quote it is that a part of this is about showing that you are gearing up to take this somewhere else, possibly to adjudication, if you don't get a satisfactory resolution. It's showing that you are prepared. You're not just sending a one line, we want to be paid. You're justifying your claim. The next one, the penultimate bullet point, is the notification of contract requirements. Now, sometimes these may be this may be you saying, we have complied. Here are our notices. They were all submitted within the timescales. And again, that's to head off any argument that there hasn't been compliance and therefore you've lost entitlement. It might also be the other way around as well, or instead of, in that you might be saying that the other party hasn't complied with notice requirements and what the implication is. And also the final bullet point here, basically, why do we say that you should pay? Why do we say you should award us this extension of time? So if we can move on to the next slide, Jen. So the letter continues. So, we've sort of dealt with the liability issue and the factual scenario. So now we need to justify the time that we want or the quantification of the claim. So, detail that out. Spreadsheets are always good. And again, it's about preparation, showing that you've thought about your strategy, showing you're gearing up for the next stage in the process. So, send your receipts, your timesheets, all your documentation to prove your quantum, your program to show the delay. Because it shows, again, you're organised, you're thinking about the next steps. This isn't just a quick letter that you've just quickly sent off, in the hope, rather than in the expectation of getting a resolution. Next bullet point, always important. What do you want your opponent to do? It's good to give 2 alternatives. Pay in full or award the extension of time is always a good one. You're probably realistically not expecting it, but if you don't ask, it sort of indicates you're lacking confidence in your claim. So ask for what you really want, but give an alternative, which might be meet within the next 7 days. It might be that they respond to the letter in 7 days and then have a meeting, but be prescriptive about it. Give them 2 options, and then the inclination is that one of them will be chosen rather than just keeping it vague. Next slide. Sorry, the next bullet point is refer to dispute resolutions and resolution clauses in the contract. Again, for 2 reasons. The first is it shows that, again, you're reviewing things, you're serious about progressing this. But the other reason is that sometimes clauses are included to require a sort of director level or high level meeting if there is a dispute. And if that is the case, there will often be a process before it, which is usually claiming party sends a letter of claim or a document of claim, and the responding party responds, and then the parties meet. So you might think, oh, well, why would, there's nothing to force them to comply with that. But generally people do, partly because they don't want to then be told, they don't want to not comply because then they'll be in breach of contract, and nobody wants to be told, you've not done the right thing, you're in breach. So, that's really helpful if you've got those provisions. Particularly if, as part of your strategy, you do want a high-level meeting. And I would have thought in most cases you do. So penultimate bullet point here, if you're proposing a meeting, so this assumes that you haven't got anything in your contract about this, but if you're proposing a meeting, you need to think about who you want to attend from both sides, because you don't want unequal attendance. And equally, if you've got to this stage, there's probably little point the two site representatives attending. They've probably discussed this already. They're very close to the dispute. They've probably got their own reasons, their own personal reasons connected to their own careers, which might, suggest that they don't want to resolve this. Whereas, bringing in some higher level people, they might have all sorts of different commercial reasons for wanting to resolve it, such as doing future work together, the fact that, one party might be thinking, well, we've got a lot of work on here, a lot of other work on, we can do without a dispute, we need our personnel to be engaged in doing these other projects, not preparing witness statements and adjudications, etc. We don't want the legal spend, etc. So lots of different reasons. But, it's critical that you have a productive meeting, so that, it's really important in any letter, you kind of set out who should attend the meeting. And finally, consider badging it a pre-action protocol letter, because then it sort of looks as if you're heading towards court. I probably wouldn't do that if it's on NEC, because with NEC you've got to adjudicate first, so it might just look as if you don't really understand that. So probably if you're on NEC, just badge it a letter of claim. So hopefully that gets you, well, it helps you to review your own claim and critically analyse it and all the elements of it. Also, the other party gets a really good, well-reasoned, well-argued letter, which it would be difficult for them, not to take seriously. The other thing, I think this is the last slide, but the other thing I would say is that when you attend meetings, first of all, you've already agreed who's attending, so you know that the parties are mirroring each other, particularly if it's going to be high level people. It's always a good idea to have somebody there from your side who knows the project and who knows these documents, if you've sent a detailed letter like this. Otherwise, the meetings tend to be, two directors meet, one will come armed with lots of information, and the other one will then have to go away and check everything with their people. The other thing is always, it's always good to have an agenda for a meeting, even if it is going to be a settlement stroke without prejudice meeting. And I think finally, with regard to at the meeting, it's helpful to go through these points. So if you're not going to send a letter of claim, you could use this as a sort of agenda of issues to go through. And I think finally, for a meeting, it's really, really good idea to go armed with questions to ask the other side. And that's aimed at getting them to critically analyse their own case, because sometimes these kinds of meetings get a little bit, I'm going to talk about my claim and I'm going to tell you why it's really good. Then you're going to talk about yours. And at each point when we're talking, the other party's just going to shut off and not listen. And by asking questions, you get the other party to genuinely think about the merits of their own claims. So it would have to be specific questions, but it's a really good way of getting people to sort of be realistic rather than doing the I'm talking, so I'm quite happy. When you're talking, I'm not really listening. So questions are good. So yeah, any questions about the seminar?
Right, thank you very much, Sarah. So there is a couple of questions